Well, good morning and welcome to our webinar. And for those of you in the Eastern time zone, good afternoon. Very excited today to have a very distinguished panel to join us to talk about some exciting developments in the world of arbitration here in the province of British Columbia. We have a new act, a new Arbitration Act that's been passed in the legislature, but not yet in force. It will be enforced in a few weeks as of September 1st. Also, we'll be talking about a new change of name for the organization that I'm the managing director of, the British Columbia International Commercial Arbitration Centre, which will soon, also on September 1st, become known as the Vancouver International Arbitration Centre. And consistent with that, we are also working on new rules that will be in effect starting September 1st for administering arbitrations. And they will be compliant and consistent with the new legislation, which, as mentioned, comes into force on September the 1st. Now, I'd like to introduce our distinguished panel. First, Jonathan Eades. He's a lawyer, a litigator with the BC Ministry of Attorney General, and we've been working closely in coordinating the rollout of the new legislation, as well as the new rules that will be consistent and supportive of that legislation. Joe MacArthur, partner at Blake's in Vancouver, and a partner of his, Laura Kandari. They've also been working hard and diligently with us in our Rules Committee as we get ready for this exciting new development in the world of arbitration. So without much further ado, I'd like to again just thank all of you for your interest and for tuning in on this webinar. And at this point, I'd like to turn it over to Jonathan Eades with the Ministry of Attorney General. Jonathan?
Yes, thank you very much, Barry. Let's move right ahead. I'm going to talk first of all about the Arbitration Act. Joe and Laura will talk about the force on September 1st, 2020. BC's cutting our links with domestic arbitration legislation that was once found throughout the Commonwealth. The new Domestic Act is based on the United Nations model law, which, as users listening today will know, has been adopted in countries on every continent in more than 100 jurisdictions and counting. And of course, BC was a pioneer in adopting the model law internationally in the mid-1980s. However, we didn't do so domestically. Next slide, please. The new act has structure. It tracks the conduct of arbitral proceedings. Our domestic act is out of date presently with modern arbitration throughout modernized jurisdictions in the world. That's about to change. A volunteer group of senior arbitration practitioners and business leaders advises the Attorney General on matters of importance in arbitration, and including legislative reform and promoting Vancouver as an arbitration venue. In 2016, a legislation subcommittee of that group was formed to recommend changes to BC's arbitration legislation. Next slide, please. In 2018, the legislation subcommittee completed 2 years of work and recommended reforms to the International Commercial Arbitration Act, updating it, and those recommendations were brought into law in May 2018. The legislation subcommittee then moved ahead with a major review of the Domestic Act, conducting comparative law research on modernized acts in other jurisdictions, including Australia and England. Next slide, please. Furthermore, the legislation subcommittee carried out a detailed review of the Uniform Law Conference of Canada 2016 Uniform Arbitration Act. There were more than 35 lengthy meetings and back and forth discussions for over 2 years, and reach out and engagement with the BC ICAC was and is active throughout. Next slide, please. As a result of this review, the subcommittee recommended that the Arbitration Act, which had been in place and in force in various forms since the 19th century, be repealed and replaced with new domestic arbitration based on the ULCC Act and on the International Commercial Arbitration Act. The ULCC Act itself, like the International Commercial Arbitration Act, is based on the model law. And as a result, there'll be greatly increased compatibility between BC's international and domestic arbitration regimes. With the Act, BC will have 2 arbitration acts, one international, one domestic, readily recognizable and understandable as model law legislation benefiting business parties, legal counsel, and arbitrators. Next slide, please. Let's talk about advantages. I'm going to go through 20 very quickly. Advantage 1, structure. The present Arbitration Act, oddly and unexpectedly, has fundamental arbitration principles, including core principles like separability and competence, embedded in the rules of the BCICAC. That's very difficult for parties to understand and follow. And if they don't if they don't follow the BCIAC rules, they may not have these core principles in their arbitration. Comprehensibility is seriously hindered. The new Act, by contrast, has a logical, easy to follow structure divided into parts, divisions, and sections, and with the main steps and sequencing of an arbitration proceeding being tracked. Just reading the new Act from start to finish will teach a reader much about the process of arbitration that the present 19th century based legislation most certainly does not. Next slide, please. Advantage 2, international harmonization. I've touched on this already. Great overlap now with the International Commercial Arbitration Act deliberately. There will now be increasing cross-pollinization in domestic and international arbitration practice in British Columbia. And note, for viewers outside this province and within Canada, the new Act also is will be much more familiar to counsel and parties from domestic arbitration jurisdictions like Ontario, the Prairie provinces, and the Maritime provinces, which have ULCC model law domestic acts too, a generation earlier, but nonetheless, you can see the bloodlines quite easily. Next slide, please. Advantage 3, relocation of family law arbitration. Family law arbitration was legislatively coupled and placed within the Arbitration Act several years ago. And the fit was thought by all practitioners, family and commercial, to be awkward. And as a result, we had calls from practitioners from the family bar and the commercial bar to make changes. Family lawyers and arbitrators formed their own working group to recommend changes, which track what we've done, but in a much more simplified version, which dovetails and is now built in directly into the Family Law Act as of September 1st, 2020. Next slide, please. The stay of proceedings, this is advantage 4, the stay of proceedings provision remains stable, however. This, as the users here will know, is one of the most important provisions within the Arbitration Act. It protects the integrity of both the legal process in court and arbitration. You need clarity to follow when proceedings in court should proceed and when they should be stayed. British Columbia in 1986 innovated with a novel stay provision, which gave all sorts of court discretion to not stay proceedings. In other words, to allow the civil litigation proceedings to continue, stopping the arbitration. The result, unfortunately, was a huge amount of litigation. And within 2 years, government brought the stay provision into alignment with the model law stay provision. This is a provision that has been enforced now in British Columbia for more than 30 years. It's very well understood by the BC courts. Our decisions from the BC courts on the stay provision are excellent. And so other than minor housekeeping matters, the provision remains the same in the new Act. Next slide, please. This is a continuation of the stay, just talking about the housekeeping changes. I don't think I need to spend a lot of time on this. There's updates in terminology to modernize it, but effectively stays the same. There was also within our stay provision a provision discussing interim measures, which had nothing to do with stays. Actually, it's properly being moved out to the new interim measure section. Next slide, please. Advantage 5, this is new. There is a 30-day limitation suspension in a suspension of limitation periods, which applies when applicable limitation periods will be suspended if a party commences proceedings in court and the court proceedings is then stayed in favor of arbitration if the claim is then made in arbitral proceedings no more than 30 days after the court proceedings are stayed. So that just gives a little bit of room for a party to not lose a limitation period because they've commenced in the wrong forum. Next slide, please. Consolidation. The present act, which will soon be replaced, does include a rudimentary consolidation provision to consolidate different arbitrations with similarities. BC has now enacted a modernized consolidation provision similar to that enacted in the International Commercial Arbitration Act and recommended by the Uniform Law Conference of Canada. The new section clarifies enforcement of consolidation agreements and provides guidance to the court in circumstances when it should consider when consolidation orders are requested. Next slide, please. Thank you. There are now clear duties on parties, tribunals, and experts. They're under arbitrators and parties are now under express duties to try and move the arbitration process forward in a just, speedy, and economical manner. So the proceeding is determined on its merits. And experts now are in arbitral proceedings appointed by the parties will have a duty to assist the arbitral tribunal consistent with similar duties which were introduced into BC civil litigation a decade ago. Next slide, please. Arbitral challenges, real danger of bias. That's Advantage 8. The provision will ensure that the grounds for challenges to arbitrators are now incorporated expressly in legislation. Again, this was formerly found or presently found for the next few weeks in external rules, confusing for parties. The grounds for challenge provision to challenge arbitrators is consistent with the International Commercial Arbitration Act. And the standard for challenges has been changed from the justifiable doubt standard and tracking English and Australian jurisprudence to elevate it to a real danger of bias. Next slide, please. Self-representation, which occurs in arbitration, it's now codified and supported by the legislation. The purpose here is to make it clear that a party does not need to be represented by a lawyer in arbitral proceedings unless the legislation regulating the practice of law so requires. The purpose here is to be consistent with the objective of facilitating the use of arbitration as an alternative to court proceedings. Next slide, please. The Act contains a codified contains a codified presumption directing that direct evidence will be in writing. This presumption confirms best arbitration practice. Hearings on the merits are largely confined to witness cross-examination. They're not meant to be about direct evidence, and this shortens hearing time and accompanying expense and inconvenience. That's a presumption that could be changed by party agreement or by arbitrator direction. Next slide, please. Now, there's been a change in production and evidence from non-parties. The arbitral tribunal is now authorized to subpoena evidence or records. It's authorized to request courts of competent jurisdiction to assist the arbitral tribunal with subpoenas. It codifies the requirements of an arbitral tribunal subpoena, permits the Supreme Court to set aside a subpoena issued by an arbitral tribunal, permits the Supreme Court to request the assistance of another court to ensure compliance with an arbitral tribunal subpoena, and permits parties to arbitral proceedings elsewhere in Canada to request Supreme Court assistance in enforcing a subpoena. Next slide, please. There are now set out procedural powers of the arbitral tribunal, Advantage 12. It's wide-ranging, it's non-exhaustive, it gives a list of items, extensive list. I'm not going to review them here, but essentially the tribunal has wide-ranging powers to establish procedures, to make procedural orders for the conduct of arbitral proceedings, and also specifically empowers, the section empowers an arbitral tribunal to administer an oath or affirmation as well. Next slide, please. There's a new section, entire part of the Act relating to interim measures and preliminary orders, which are similar to injunctive relief. This is a direct adoption from updates to the model law It tracks the International Commercial Arbitration Act. It's found in numerous jurisdictions in the world. It's a complete detailed code dealing with similar relief as would be found in court injunctions. Next slide, please. There's new powers to withhold an arbitral award. An arbitral award can be withheld now under statute until the arbitral tribunal has received full payment. It extends the time limit for giving the award until security is provided. And if there's disputes on these matters, and Joe and Laura may touch on this, it allows the party to apply to the designated appointing authority under the Act, that's VanIAC, the new Vancouver International Arbitration Center, for directions relating to the delivery of the award, summary determination of fees and expenses, etc. I won't spend any more time on that. Next advantage, please. As similar, they'll probably touch on this. There's a new section for fee disputes, relating to fee disputes with arbitrators and parties. Again, there's a process established in the Act to allow VanIAC to make, that's Vancouver International Arbitration Center, to make a summary determination of arbitral fee and expense disputes. Next advantage, please. Yeah, Advantage 16 is very important. There's been problematic law in British Columbia that has been now overridden and clarified. Arbitrators now have clear authority to do the following: award equitable remedies, determine cost awards summarily, and award compound interest. And the Act also confirms a matter frequently assumed, but often without proper foundation, that arbitration proceedings are now presumptively confidential, and that can be overridden in certain circumstances according to law, again consistent with the International Commercial Arbitration Act. Next slide, please. Another change in the Act is the replacement of the unique to BC concept of arbitral error. Instead, now the Act has a model law set-aside provision to set aside the award in situations of serious irregularity. Consistent with the International Commercial Arbitration Act, set-aside applications will be brought to the BC Supreme Court, and there's a new time limit for bringing a set-aside challenge, 30 days, not 60, as under the present legislation. Next slide, please. One of the major changes is restructured and streamlined appeals. I think everyone on this webinar will agree that 5-month arbitrations start to finish before a single arbitrator should not lead to 5 years of litigation before 17 judges. And many people here have litigated the cases in question: SATFA, Urban Communications, Waste Tech, and similarly, although it had its own unusual features, Gel and Boxer. That is a process that is not consistent with quick and final dispute resolutions, which should be the focus of arbitration. So as a result, 2 complete steps before the BC Supreme Court in the present cumbersome appeal process have been eliminated. The new Act provides that leave applications on questions of law arising out of an arbitral award will be brought exclusively to the BC Court of Appeal. That's a major change. The statutory constraints for leave grants, questions of importance, however, are unchanged from the present Act. Parties can now opt out of the leave stage. Parties can now opt out of appeals altogether. And importantly, set aside and appeal applications are now separated. Different courts, different evidentiary materials before the courts. Appeals arise from the award, not the underlying evidence. And that's not necessarily the case for set-aside applications. Again, a 30-day time limit, not 60. Next advantage, please. Immunity. There's an immunity provision consistent with the International Commercial Arbitration Act, consistent with other jurisdictions. It prevents legal proceedings for damages against arbitrators for acts other than those done in bad faith. As I just mentioned, we're now consistent with our own international act, and this will hopefully limit disruptive challenges to arbitral proceedings. Next advantage, please, is the VanIAC rules. And I'm going to turn this over to Joe and Laura. Thank you.
Jonathan, thank you very much. And Laura and I are going to talk about the new rules that VanIAC has introduced, and a little bit about VanIAC itself. And what became clear to us was that kind of the dramatic changes that Jonathan has just spoken about. When you look at the new Domestic Act compared to the old Act, it was clear that our existing domestic rules at the center were going to have to be dramatically changed as well. And we had a rules committee put together, which consisted of Les Maroff, who's the chair of our board of directors, Peter Singpill from Nathan Schachter Thompson, Laura, and me. And we went through and did a complete overhaul of the rules. So when you look at them as counsel or as a user or as an arbitrator, if you've got them and they're applicable after September, arbitrations commenced after September 1st, you'll see that they're completely different. And along with these changes to the rules, you'll see that we've also created much less of a mouthful from BC ICAC to VanIAC. As of September 1st, we will be known as the Vancouver International Arbitration Centre, or VanIAC, instead of the BC ICAC. So let me just move to kind of the general approach that we took to the new rules. As Jonathan's talked about already, the new Act covers many of the procedural issues which were only addressed in the BC ICAC rules, which were kind of applied by default under the old Act. Now, a number of those procedures, since they're now addressed in the new Act, it meant for us as the Rules Committee, we had to decide at the front end what kind of approach we were going to take. And we decided there was a choice between creating new rules that could stand alone and by themselves without the Act, which would require duplicating, frankly, a number of the new procedural provisions in the new Act, or whether we would approach the rules in a different way on the basis that these new domestic rules are meant to be read with the new BC Act, and to make it so that the rules are a supplement to the Act, but an important supplement for parties, and to give parties a good reason to use her and its experience, and these new rules would give parties certain procedural options that wouldn't be available necessarily under the new Act. So now the new rules are meant to be read with the Act, and those of you that have seen them, which should be everyone on the call, I think everyone on the webinar got a copy of the new rules. They are meant to be read together with the new Act. They don't particularly stand on their own without the Act. There's a number of provisions that aren't dealt with in the rules because they are dealt with comprehensively in the Act. And we are preparing a roadmap for parties with respect to the new Act and the new rules and how they work together. And you'll see as part of the new rules as well that we've included a number of VanIAC forms that will be available to parties for when they're filing their notice to arbitrate or dealing with document requests, and a number of other of the procedural steps that you'll take during the arbitration process. So one of our objectives, as I said before, was to make sure that these new rules were providing real benefits to parties that have already agreed that the center will administer their arbitration, as well as encouraging parties to continue to use the center to administer their arbitrations in the future. And I think we've provided a number of new options and opportunities in our rules that will give parties a good reason to continue to use the center and its experience in administering arbitrations. We also wanted to make sure, Jonathan talked a little bit about the new legislative authority that VanIAC has under the new act, dealing with appointments and dealing with arbitrators' fees and so on. And these are obligations that the center has regardless of whether or not they are administering the arbitration. And we wanted to make sure we had a procedural structure for those new responsibilities. And finally, we wanted to make sure that we were, as best as we could, institutionalizing some best practices from, particularly from the international arbitration experience, into our domestic rules. And so I'll turn now to some of the highlights of our new rules. And Jonathan talked about some of the best practices from a procedural perspective that are now included by default in the Act. And so if we just go back a page on the slide, there we go. Jonathan talked about some of the best practices that are included in the Act. And we wanted to make sure that some of the best practices dealing with the exchange of materials, dealing with document production, and other things that would make the hearing as efficient as possible and make the process as efficient and yet still as fair as possible were being captured by our new rules. And in our experience, a number of the new kind of default best practices that we've included in the rules were already being incorporated by experienced arbitration counsel and experienced arbitrators in their initial procedural orders. But not everyone was doing it the same way, and not everyone has to do it the same way. That's the beauty of arbitration. The new rules, protect that flexibility. But with the new rules, we've set out some default best practices that we find were being applied by experienced arbitrators, experienced arbitration counsel, in a number of cases dealing with witness statements, arguments, expert reports, and document production. We wanted to have that as a default so that for less experienced counsel and less experienced arbitrators, they would have a default of some of the best practices that apply in arbitrations. Again, still allowing for that flexibility for cases that are different and might call for a different type of procedure, but saying that this is a default that you should consider applying in most cases. And so one notable example, in addition to the exchange of materials that we've talked about, is the exchange of document requests. So dealing with document production, often a difficult issue for arbitrators, arbitration counsel to deal with, and one of the issues that in some ways arbitration can deal with more efficiently than court, in most ways, frankly. And we wanted to make sure we maintained that advantage, that arbitration advantage in dealing with document production by really requiring document production to be really directed, really focused document production, and not to have the broad document production requirements that you'd have in court. And one of the ways that we've done that is the default. Again, there's flexibility depending on the case, but the default for document production is that the parties will exchange document requests after the first exchange of submissions. So the parties will put in their case as they have it, including witness statements, arguments, and expert reports. The other party will respond to that as they have it with the documents they have in hand. And then the parties will say, based on the material that we've provided, these are the additional documents we need. And this allows for a much more meaningful and focused determination of the relevance of certain documents and requirements for production. And so the hope is that's one of the new tools that's in our new rules that will help parties keep the process as efficient as possible. Let's go on to the next highlight. I'm also going to address the emergency arbitrator procedure. So Jonathan talked about the new interim measure provisions in the Act. And what the new rules have done is they've taken those provisions and made it possible for parties to apply for emergency relief before a tribunal is in place. So before you've commenced the arbitration, appointed the arbitration tribunal, we've created a procedure that allows for an emergency arbitrator to be appointed within 2 days of the application being made to the center, who will then have the authority to grant interim measures. And we think this provides an important option for parties, so that you don't have to, before a tribunal has been appointed, go to court to get an interim measure, and thereby perhaps once you're going to court on those interim measure applications, you've lost some of that confidentiality that parties often really appreciate about arbitration. And this way, you're able to bring an interim measure application and maintain the confidentiality of the proceeding and have it dealt with by arbitrators. So the emergency arbitrator is meant to step in and deal with their interim measures until the tribunal has been appointed. And there's kind of detailed provisions that deal with that. In addition, there is also the opportunity that's to grant preliminary orders. And what these are like is it allows for an ex parte application before an emergency arbitrator for a preliminary interim measure. And that's really akin in court to an interim injunction that's in place until the actual interlocutory injunction is heard. And that's the intention. And it follows the Act. The Act provides for that as well, but we provide the procedures to have that type of preliminary order made before you've actually appointed an arbitration tribunal by appointing an emergency arbitrator under the Act. And I think that will be a really helpful tool for parties where there are interim measures issues that arise before the tribunal has been appointed, which is often the case. And so I think this will provide a lot of opportunities for parties to use these new tools. I'm going to turn over to Laura to touch upon some of the other highlights. One we're really excited about, which is our new expedited procedures for claims under $250,000. And I'll let Laura talk about those procedures now. Go ahead,
Thanks,
Laura.
Joe. So the expedited procedures, as Joe says, we're quite excited about. It's something totally new, and we think it will be something that will be appealing to various parties. It is intended to apply to claims under $250,000. So that would be both a claim in chief and any counterclaims. Both claims, each of them have to be under $250,000 for these rules to apply. It's important to understand that if you agree to arbitrate under these rules, unless you opt out of the expedited procedures, if your claim is under $250,000, you will be operating under the expedited procedures. There are a couple exceptions to that. For example, if your arbitration agreement says that you will have a panel of 3, you won't fall under the expedited procedures. And there's also the ability for the center to look behind the claim and make sure that it is actually suitable and the quantum is actually under $250,000. There's also the ability for parties to opt into these procedures if their claim is in excess of $250,000. But in that circumstance, the flat fee arrangements, which I'll discuss, won't apply, but they can still use the expedited procedures. So the arbitral tribunal will be compensated on a flat fee. All of this works hand in hand. We have a very expedited schedule, which for the most part will be done entirely in writing. And as a result, we're able to set a fixed fee for the arbitral tribunal's fees. Those fees won't apply where parties have agreed to use the procedures, but they're not under that $250,000 threshold. And there's some variation in that as well if an oral hearing is required. So there won't be an oral hearing unless the arbitrator determines that it is necessary to have an oral hearing. And necessary is determined having regard to the tribunal's duties under Section 21 of the Act. Jonathan touched on those. The duties are to treat each party fairly, give them a reasonable opportunity to present their case, and importantly, embedded in the new Act, to achieve a just, speedy, and economical determination of the proceeding on its merits. So if, taking all that into account, the tribunal determines it's necessary, it can order an oral hearing. That application comes after all the written material has been submitted. So at that point, the parties and the tribunal will have a better assessment of whether an oral hearing is necessary, as opposed to just at the beginning of a proceeding, the parties wishing to have an oral hearing. If there is going to be an oral hearing, it's restricted to a maximum of 1 day, unless, again, the tribunal determines that it is necessary to have a longer hearing. And as I mentioned at the outset, there's an expedited timeline for these proceedings. All written material will be submitted within 90 days of appointment of the arbitrator, and an award will be issued within 30 days of the last written material being submitted, or within 45 days of the conclusion of any oral hearing. And something else that's important to be aware of with respect to these expedited procedures is that there will be no appeal without consent for arbitration agreements entered into after September 1st, 2020. So if you enter into an arbitration agreement after September 1st and you choose to use these rules, unless the parties agree that there will be an appeal, there will be no right of appeal of the expedited procedures award. We have included virtual hearing proceedings rules. These are, for the most part, less prescriptive than other rules. They're more to provide guidance and to institutionalize some of the best practices that have come out of virtual hearings in the past, in particular, the experience that parties have had in light of COVID-19. And there have been many arbitration hearings proceeding virtually or in a hybrid format. And so, for example, the rules discuss that the arbitral tribunal can issue directions on what type of platform to use, for example, and also sets out a number of matters that the arbitral tribunal shall consider in issuing directions, just to ensure that parties have some basic guidance to make these virtual proceedings work. We think that these proceedings are going to continue to be used readily after the COVID-19 situation, because parties are seeing that these hearings can work, they're efficient, and many of the costs associated with an in-person hearing can be avoided through virtual proceeding. One of the other features that we've put in our rules is the ability to opt into an appeal tribunal, which would replace an appeal under the Act. So as Jonathan mentioned, you can now opt out of appeals in your arbitration agreement, but parties may still wish to have the ability to appeal the tribunal's decision while keeping it confidential and also enjoying some of the other benefits of arbitration. This will allow them to select proceeding by way of appeal tribunal. The appeal would be on a question of law if the parties agree in their arbitration agreement, or if they agree after the arbitration commences. So parties can agree once the arbitration has been commenced that if at the conclusion of the arbitration, they would like this ability to appeal to an appeal tribunal, or they can set that out in their arbitration agreement. The appeal tribunal can also consider questions of mixed fact and law, or fact or any other specified grounds if the parties set that out in their arbitration agreement. The effect of filing an appeal to an appeal tribunal is that the underlying arbitral award cannot be enforced in court, it cannot be appealed, and there cannot be a motion to have it set aside while the appeal is pending. And as a result, any time periods for those court applications are tolled while the appeal is pending. The appeal process, though, won't replace the ability to seek correction or interpretation or any rights under Section 56 of the Act before the original arbitral tribunal. And by consenting to an appeal under this part, the parties also are expressly agreeing that they won't appeal any question of law arising from the arbitral award or the appeal tribunal award. So it gives the parties, this in conjunction with the ability to opt out of appeals in the Act, gives the parties a lot of option in terms of what they want to do in terms of finality, and also keeping their appeals private and in the form of an arbitration. One of the highlights we think for our panelists is that there will be a number of new opportunities for arbitrators to act in a variety of capacities. We will need panelists to act as emergency arbitrators. We will need them to act as cost assessors, members of appeal tribunals. And in particular, under the expedited rules, we think that this is going to give arbitrators who perhaps are starting out or don't have a ton of experience, the ability to do some arbitrations under the expedited rules and gain that experience and provide the parties with the benefit of a reduced flat fee. So the first question we have is on, the individual has asked about technical dispute adjudication or expert determination and whether that has a role in this scheme. Maybe Joe, I'll start with you as to whether you think there's any role for that in what we've talked about today.
You know, expert determination is a really interesting question, and one that the case law is a bit mixed in Canada with respect to it. It's a challenging issue. You know, technically, expert determination is if it's properly drafted as an expert determination, is not meant to be an arbitration. The expert isn't meant to be acting as an arbitrator. They are meant to basically be, it's a contractual provision, and the parties are meant to be bound by whatever that expert determines. But there's some crossover with arbitration, and at times a provision that parties think they're drafting as an expert determination provision turns into an arbitration provision, in which case you may be captured by the Act and potentially by our rules. Our rules are not meant to deal with a true expert determination, but they are meant to deal with an expert determination that is found to be an arbitration under the Act and therefore under our rules. But really, if you're drafting an expert determination clause in a mining contract, it might be a dispute about assay results or something, and that you appoint an expert to determine those results, and the parties agree they'll accept them. It really shouldn't be falling under arbitration. But that's different. Just it's a bit different though than appointing, let's say, a evaluator to act as an arbitrator. In which case, that would be captured by both the Act and by our rules if you're having it administered by the center.
Jonathan, did you want to add anything to that?
No, I think that's an excellent summary. I agree with that.
And the next question is for you, Jonathan. What was the impetus for allowing parties to opt out of appeals? Party
autonomy, allowing the flexibility. People said that they wanted that option. Other jurisdictions in Canada have that option. Australia has that option. It made sense to give them the flexibility. They don't have to, but they can now do so.
Laura,
yes.
Just add to that, about 4 years ago at the BC International Commercial Arbitration Center, which, as you know, will soon be VanIAC or Vancouver International Arbitration Center, we did develop an amendment to our domestic rules that gave parties the option to opt into an appeal process internal to the center. So you could have a three-party panel review a matter rather than having to go up to court if one side or the other was dissatisfied with the arbitrator's decision.
Great. Question for Joe. Who appoints the emergency arbitrator?
The center appoints the emergency arbitrator. And so that will be up to the center to do so. So it's a bit of a different type of procedure than you'd usually have for the appointment of arbitrators, but the center will be making that determination and making that appointment.
Now, question for you, Jonathan. You set out that the Act tracked reforms adopted in Australia and the UK to a great extent. Were there significant differences that you chose not to adopt into our act?
That's a big question. I would say there's a large degree of concurrence. Australia, I would say, has more consistency between international and domestic than we have. We've allowed some tease out. Our appeal provision is a little bit more detailed than theirs is. That's just one example. They've really tried to have almost complete harmony. We have some differences. So the example is the role of VanIAC. They have no equivalent to that in Australia or England. That's a really unique BC feature that we have found after 35 years of working with the center, the BCIA-CAC, to be incredibly valuable. We wanted to preserve that relationship. That's a major difference between us and everybody else, including Australia and England and the rest of Canada.
Barry, I've got a question for you. The question is, has there been an increased use of the center during the COVID pandemic? And do you expect that to continue if there has been an increase into the future?
We are having our busiest year ever. It has been a very busy time. We have been able to maintain operations without any pause throughout the pandemic. So I know while the BC Supreme Court has been struggling more than usual to handle cases and case flow, we've been able to continue, and we're pretty quick to move seamlessly to online platforms similar to this for virtual hearings. And for that, we have to commend our panelists and all the participants for being flexible and being willing to adapt quickly. But yes, we have been busy. Can I point specifically to the pandemic? Can't prove it, that it's related to that. We were already busier in January and February than previous years. So it's just that the trend has maybe been accelerating. And certainly we have been able, and I want to thank our staff and any of the people watching this who've dealt with their staff know how capable they are. Erna and Ina at our office, they've been very supportive of all the participants this year that have been using the center.
Great. For Joe, the rules are meant to be read with the act, but isn't that problematic if the seat is not in British Columbia?
Yeah, and so there is some potential for that. Now, one way we've dealt with that issue is the new rules have a provision that by adopting the rules, the parties agree, unless they say otherwise in their arbitration agreement, that the legal seat of the arbitration will be Vancouver, in which case the BC Act would apply by having the center administer the rules. But there could be issues with using our rules with, if you have the legal seat in Toronto, for example, there may be some issues, although as Jonathan notes, there's a lot of similarities between the two acts, but there is some danger of there being a little bit of a gap for that. And I think part of that will be dealt with when we come to amending our international rules, which I think will be suitable for arbitrations anywhere, wherever you have the legal seat, regardless whether it's in elsewhere in Canada or around the world. I mean, those rules exist right now, but as Laura and Barry are well aware, that's next on the Rules Committee's agenda, is to take some of these new ideas that are in our new rules and adopt our international rules to accommodate those new options, those new opportunities for parties that take advantage of some of the advantages of arbitration.
The next question is with respect to the various rosters for panelists and whether separate rosters will be maintained for all the different types of appointment we've talked about: emergency arbitrator, appeal tribunal, and expedited procedures. Joe or Barry, do you want to speak to that?
Well, I think I think separate in the sense that there'll be some panelists that will be part of available for the appeal tribunals. There'll be some panelists available for as an emergency arbitrator, and there'll be some panelists available for the expedited procedures, and some panelists will do it all. And that'll be something that we will be talking with panelists about in the coming weeks with respect to which of those new roles the panelists would like to do, and provided they're well suited to them, we'll be doing that. And I expect what we'll see is that there will be some new panelists, particularly to deal with expedited procedures, who will be available for appointment for those procedures in particular.
Jonathan, I think this question is for you. It's a question about the confidentiality provision in the Act. And is there any remedy for breach of confidentiality in an arbitration?
It could be a contractual remedy if you seek it. There's no remedy under the Act. Confidentiality is always a problem. There's also some off-ramps from that provision itself, basically protecting the rule of law. Confidentiality can't be an absolute provision. There are situations where you have to step behind it, but it's meant to provide a structure for the provision of the Act, just like the International Act, to provide a baseline of confidentiality, an expectation of confidentiality. And if breaches occur, by the way, during the arbitration, there's the ability for remedies, of course, in the arbitration itself.
Thanks, Jonathan. So the next question is whether parties subject to the former version of the rules will be encouraged to upgrade, so to expressly adopt the new rules, and whether VanIAC will provide any wording to parties to ensure that upgrade is validly done.
It'll be up to the parties where the old rules apply. The old rules apply, so it'll be up to the parties if they want to come to an arrangement for the new rules to apply. But I'm not sure the center has a proper role in that. I think that's really for the parties, but it's certainly something we can think about. We haven't addressed that as of yet.
Joe, September 1st is an important date, of course, though. That's the trigger date for the operation of the new Act, and arbitrations commenced with the center after September 1st would be governed by that new Act. That would and if they wanted the rules to apply, the VanIAC rules, they would be the new rules, correct?
That's correct. Yeah. So September 1st is the key date. If you're starting an arbitration after September 1st, then the new rules apply, and so that's Jonathan's quite right, and the new Act applies. There's a couple of exceptions to that in the rules where there's certain substantive rights that are being dealt with in terms of appeal rights, though are referenced, that are only applicable to arbitration agreements entered into after September 1st. But for the most part, any new arbitration commenced after September 1st that has the center administering the arbitration will be subject to the new rules.
Jonathan, I've got a question about Section 12, which relate to the limitation period being postponed if court proceedings are started and then stayed.
Okay.
And the question is whether there is a mirror image provision so that if arbitration proceedings are commenced and the arbitrator finds no jurisdiction to arbitrate, is it possible that the limitation period may lapse for bringing court proceedings while the arbitration proceedings are ongoing?
Yeah, excellent question. No, there is no such mirror provision. It's really meant to dovetail with the stay provision alone. So it works in one direction.
Question for perhaps Barry or Joe about whether you see more international panelists participating in these domestic proceedings, given more things are going virtual now.
I think that's a definite possibility. It's still a bit early days. We have picked up some additional international cases this year. That's part of our increased workload overall. But again, I don't know if I can point specifically to the pandemic yet for that. But I do think the move to virtual online hearings will just make everything easier in terms of replacing travel and really closing the distance between continents.
Great. Jonathan, question for you. Is this correct that the parties are free to agree on a seat of arbitration but if BC is the seat by choice or default, the parties cannot contract out of or modify the provisions of the Act.
Partially correct. The Act applies, but the Act is filled with abilities for modification. They're far too numerous to list. There's got to be 30 different provisions in the Act at least that are subject to modification. So yes, BC Act applies, but the ability to modify that Act is extensive and it's easy to follow. Frankly, under the present Act, you can modify a lot too. It's just not intuitive and easy to sense when that is. Now it's very, very easy. It says subject to party agreement, subject to agreement throughout the Act. That's triggering and letting you know when the Act applies. There's also some mandatory provisions which are expressly set out that cannot be varied. So easy to follow now.
Great. All right, well, that's all the time we have. I want to thank my co-panelists and Barry for the introduction and comments at the beginning. And also like to thank everyone who joined us today and for all your engaging and questions as well.
Thank you very much.
Thank you.
Thanks, everyone. And also just to watch out, we'll be launching a new and refreshed website to reflect our new name on September the 1st. So it'll be at vaniac.org for all your arbitration needs.
Great. Thanks, everyone.
Bye-bye.
Thank you.